As mentioned above, inferior performance constitutes a material breach that impairs or destroys the essence of the contract. In other words, it should be noted that a material breach of a contract occurs when a party renders inferior performance of his or her contractual obligation that impairs or destroys the essence of the contract. There is no clear line between a minor breach and a material breach. A determination is made on a case-by-case basis. Where there has been a material breach of the contract, the non-breaching party may rescind the contract and seek restitution of any compensation paid under the contract to the breaching party. The non-breaching party is discharged from any further performance under the contract. Alternatively, the non-breaching party may treat the contract as being in effect and sue the breaching party to recover the damages. Now, let's take the following case as an example. A university contracts with a general contractor to build a new 3-story classroom building with classroom space for 1,000 students. The contract price is $100 million. However, the completed building cannot support more than 500 students because the contractor used inferior materials. The defect cannot be repaired without rebuilding the entire structure. Because this is a material breach, the university may rescind the contract, recover any money that it has paid to the contractor, and require the contractor to remove the building. The university is discharged of any obligation under the contract and is free to employ another contractor to rebuild the building. However, the building does meet building code so that it can be used as an administration building of the university. Thus, as an alternative remedy, the university could accept the building as an administration building, which has a value of $20 million. The university would owe the amount, $20 million, to the contractor. So, in brief, as we have already seen, the breach is material when performance is not at least substantial. If there is a material breach, then the non-breaching party is excused from the performance of contractual duty and has a cause of action to sue for damages resulting from the breach. If the breach is minor, not material, the non-breaching party's duty to perform can sometimes be suspended until the breach has been remedied. But the duty to perform is not entirely excused. Once the minor breach has been occurred, the non-breaching party must resume the performance of the contractual obligation undertaken. Any breach entitles the non-breaching party to sue for damages, but only a material breach discharges the non-breaching party from the contract. To work out whether a sufficiently material breach has occurred, it is vital to consider the characterization of the term of the contract, as well as the practical effect of the breach. This, of course, ties with the classification of the term, which shows the importance of the term and the seriousness of the consequences of a breach of that term. For more clarification, a breach of an essential term allows the innocent party to terminate the contract and recover damages for any loss caused by that breach. Or instead, the innocent party may prefer to elect to affirm the contract and continue with the contract, but simply just claim for damages. By contrast, a breach of a term that is a non-essential term only allows the innocent party to recover damages for the loss caused by that breach. In this case, the innocent party is not entitled to terminate the contract. Just a brief reminder, As previously discussed, a term can be treated as an essential one if it is classified as such in the statute, or if the party expressly intended for it to be an essential term, or if the court interprets it as being a core term because it deemed essential to the party agreement, that is, the promisor knew that the promisee would not have entered the contract without that term being included. However, a term is classified as non-essential term if a breach of such term would not affect the intended purpose or benefit of the contract. In short, the rule on material breach allows contract to go forward when only minor breach, but allows them to be terminated if material breach occur. Now, we can take the following case to clarify that. In case Sharp and Cover-It Incorporation, as published by the Appellate Court of Connecticut in 2004, the very important question arises is that under what circumstances is an employer excused from further performance under a contract with an employee? Here gives the background and fact of the case. In November 1997, Cover-It Incorporation hired Khalid Shah to work as its structural engineering manager. Shah agreed to work a flexible schedule of 35 hours per week. In exchange, he could receive an annual salary of $70,000 for 5 years, a 2% commission on the sale of products that he designed, 3 weeks of paid vacation after 1 year, a company car, time off to attend to prior professional obligations, and certain other benefits. Either party could terminate the contract with 90 days written notice, but if Cover-It terminated it, Shah could receive monthly payment for the rest of the 5-year term. In June 1998, Shah went on vacation and did not return until September. In mid-October, the president and also the owner of Cover-It terminated Shah's contract. Shah filed suit in the Connecticut State Court against Cover-It and others. The court determined that Shah had breached the contract and rendered a judgment in the defendant's favor. Shah appealed to a state intermediate appellate court. And what happened in the language of the court? On appeal, the plaintiff claims that the court improperly found that he had breached the contract, or in the alternative that any breach was not material. Specifically, the plaintiff argued that the court failed to identify an express term or condition that were breached, and instead merely found that certain acts considered together demonstrated a material breach prior to the termination of his employment. Therefore, according to the plaintiff, the defendants were not relieved of their obligation under the terms of the contract to pay his full salary for 90 days and to pay his post-termination salary pursuant to the schedule set forth in the contract. So, is it a general rule of contract law that a total breach of the contract by one party relieves the inter party of any further duty to perform further obligation under the contract? It also clarified in section 241 of the Restatement Second of Contract. It provided that in determining whether a failure to render or to offer performance is material, the following circumstances are significant. First, the extent to which the inter-party will be deprived of the benefit which he reasonably expected. Second, the extent to which the inter-party can be adequately compensated for the part of that benefit of which he will be deprived. The third one, the extent to which the party failing to perform or to offer to perform will suffer forfeiture. And the last, the likelihood that the party failing to perform or to offer to perform will cure his failure, taking account of all the circumstances, including any reasonable assurance. And moreover, it should be noted that the other factors should be considered, that is, the extent to which the behavior of the party failing to perform or to offer to perform comports with standard of good faith and fair dealing. So the standard of materiality are to be applied in the light of the fact of each case in such a way as to further the purpose of securing for each party his expectation of an exchange of performance. Section 241, therefore, states circumstances, not rules, which are to be considered in determining whether a particular failure is material or not. In the present case, the court found that the plaintiff took a 10-week vacation, which exceeded the time authorized. After the plaintiff returned, he reported for work only 2 or 3 days per week and spent long periods of time visiting internet websites that were unrelated to his professional duty. Additionally, after being instructed by Cover-It, Human Resources Manager to document his attendance by use of a time clock, the plaintiff refused and simply marked his timesheet with a P for present. Last, the court found that when the owner asked when certain designs could be completed, the plaintiff responded that he was not sure and that he would take his time in completing them. When reviewing those findings in light of the factors set forth in Section 241 of the Restatement, the second version of contract, we conclude that the court finding of a material breach was not clearly erroneous. It is clear from the court finding that the plaintiff failed to perform under the obligation of the employment contract. One cannot recover upon a contract unless he has fully performed his own obligation under it, had done the performance, or had some legal excuse for not performing. As a result of the material breach by the plaintiff, the defendant was excused from the further performance under the contract and were relieved of the obligation to pay the plaintiff his full salary for 90 days and to pay his post-termination salary pursuant to the schedule set forth in the contract. So now, it's very important to get the decision and remedies in this case. The State Intermediate Appellate Court affirmed the judgment of the lower court. The Appellate Court held that Shah had materially breached his contract with Cover-It, and that the breach accused Cover-It from further performance of its contractual duty, including any obligation to continue paying Shah's salary. Now, in conclusion, you can see the table of summary of types of performance and the legal consequence relating to those types. If complete performance occurs, the contract is discharged. In case of substantial performance, which constitutes a minor breach of the contract, a non-breaching party may recover damages caused by the breach. Where there is an inferior performance, which constitutes a minor breach of the contract, a non-breaching party may either rescind the contract and recover restitution, or affirm the contract and recover damages caused by the breach.